Hey, folks, did you know that the operations and investigative standards model that ICAC had used that governs their abilities and their conduct online prior to 2012 said that they were specifically prohibited from being on adult dating sites, social media sites, and similar. And why is that? Because they recognized what a dangerous business it would be playing around where adults were acting lawfully, though in a very, very vulnerable setting, such as a dating setting or a hookup setting, where there was kink and things of that sort that was on the fringes of society, perhaps, but not illegal. They recognized that they might violate people's First and Fourth Amendment rights, among others. Did they care after 2008? Not much. And increasingly, they cared less and less. Under pressure from Congress, they decided that they would excise or cut that part out. And after 2012, the part about, of violating people's rights online disappeared. And you began to see in the courts too talk of you have no privacy online, you have no expectation of privacy, which is utter ludicrousness. Even judges don't believe that. In the book Policing Without Permission, Professor Barry Friedman, talks about an experiment where he tested that when one of the Supreme Court justices was still alive. They did a test and they doxed him to some degree and his wife and just published their personal information, their addresses, their phone numbers. They're public officials after all, right? And this justice did not like it at all. And other judges have kept that expectation of privacy thing as part of their jurisprudence until it's directed toward them, and suddenly they don't like it. So it just goes to show you another aspect of the two-tiered justice system, and where we have constant and repeated erosions of the U.S. Constitution by our police, by our prosecution, by our judges, by our legal system charged with protecting us and upholding that same Constitution.